courtroom, the defendant's present in court with counsel. Anything to the record for the state?
No, Your Honor.
Anything to the record for the defendant?
No, Your Honor.
Let me invite the jury in. Members of the jury, this is a criminal action entitled the State of North Carolina versus Joanna Madonna. The defendant is being tried upon the charge of first-degree murder. All of the evidence has been presented. It is now your duty as jurors to decide from this evidence what the facts are. And nothing is a fact until you, the jury, find it to be so. You must then apply the law which I am about to give to you to those facts. It is absolutely necessary that you understand and apply the law as I give it to you, and not as you might have thought it was, or as you might like it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied to their lawsuit in each of North Carolina's 100 counties. The defendant has entered a plea of not guilty. The fact that she has been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, they are not required to prove their innocence. They are presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. What is a reasonable doubt? A reasonable doubt is a doubt which is based on reason and common sense, arising out of some or all of the evidence, or the lack or the insufficiency of the evidence as the case may be. Proof beyond a reasonable doubt means that you must be fully satisfied or entirely convinced of the guilt of the defendant as to the matter you're considering. The term beyond a reasonable doubt does not mean beyond all doubt or beyond all possible doubt. It means beyond a reasonable doubt. You are the sole judges of the credibility, the believability of each and every witness. That is, their worthiness of belief. You must decide for yourselves whether to believe the testimony of any witness, for you may believe all, or any part, or none of what a witness has said on the witness stand. In determining whether to believe any witness, you should apply the same test of truthfulness which you do apply in your own everyday affairs. As applied to this trial, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness testified, the manner and the appearance of the witness, any interest, bias, or prejudice the witness may have, the apparent understanding and the fairness of the witness, whether the witness's testimony is reasonable, and whether such testimony is consistent with other believable evidence in the case. You are the sole judges of the weight to be given to any evidence. By this I mean if you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all other believable evidence in the case. When evidence has been received tending to show that at an earlier time a witness made a statement which may be consistent with or may conflict with their testimony at this trial, you must not consider such earlier statement as evidence of the truth of what was said at that earlier time, because it was not made under oath at this trial. If you believe that such earlier statement was made, and that it is consistent with or does conflict with the testimony of that witness at this trial, then you may consider this, together with all other facts and circumstances bearing upon the witness's truthfulness, in deciding whether you will believe or disbelieve the witness's testimony at this trial. There are two types of evidence from which you may find the truth as to the facts of a case: direct evidence and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct evidence or circumstantial evidence. Nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all of the evidence in this case. After weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find her not guilty. Now I'm going to have the sheriff pass among you a copy of my instructions to you on the charge. Do not read ahead on these instructions. I want you to follow along with me as I read these instructions to you. Thanks, sir. The defendant has been charged with first-degree murder. Under the law and the evidence in this case, it is your duty to return one of the following verdicts. 1, guilty of first-degree murder. Or 2, guilty of second-degree murder. Or 3, guilty of voluntary manslaughter. Or 4, not guilty. First-degree murder is the unlawful killing of a human being with malice and with premeditation and deliberation. Second-degree murder is the unlawful killing of a human being with malice, but without premeditation and deliberation. Voluntary manslaughter is the unlawful killing of a human being without malice and without premeditation and deliberation. The defendant would be excused of first-degree murder and second-degree murder on the ground of self-defense if, first, the defendant believed it was necessary to kill Jose Perez in order to save the defendant from death or great bodily harm. And second, the circumstances as they appeared to the defendant at the time were sufficient to create such a belief in the mind of a person of ordinary firmness. In determining the reasonableness of the defendant's belief, you should consider the circumstances as you find them to have existed from the evidence, including the size, age, and strength of the defendant as compared to Jose Perez, the fierceness of the assault, if any, upon the defendant, and whether Jose Perez had a weapon in his possession. The defendant would not be guilty of any murder or manslaughter if the defendant acted in self-defense, and if the defendant did not use excessive force under the circumstances. A defendant does not have the right to use excessive force. A defendant uses excessive force if the defendant uses more force than necessary or more force than reasonably appeared to the defendant to be necessary at the time of the killing. It is for you, the jury, to determine the reasonableness of the force used by the defendant under all the circumstances as they appeared to the defendant at the time. Furthermore, the defendant has no duty to retreat in a place where the defendant has a lawful right to be. The defendant would have a lawful right to be in the defendant's motor vehicle. Therefore, in order for you to find the defendant guilty of first-degree murder or second-degree murder, the state must prove beyond a reasonable doubt, among other things, that the defendant did not act in self-defense. If the state fails to prove that the defendant did not act in self-defense, you may not convict the defendant of either first or second-degree murder. However, you may convict the defendant of voluntary manslaughter if the state proves that the defendant used excessive force. For you to find the defendant guilty of first-degree murder, the state must prove 6 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed Jose Perez with a deadly weapon. Malice means not only hatred, ill will, or spite, as it is ordinarily understood, but it also means the condition of mind which prompts a person to intentionally take the life of another, or to intentionally inflict serious bodily harm that approximately results in another person's death without just cause, excuse, or justification. If the state proves beyond a reasonable doubt, or it is admitted that the defendant intentionally killed Jose Perez with a deadly weapon, or intentionally inflicted a wound upon the deceased with a deadly weapon that approximately caused Jose Perez's death, you may infer first that the killing was unlawful, and second, that it was done with malice. But you are not compelled to do so. You may consider this along with all other facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. A knife is a deadly weapon. Second, the state must prove that the defendant's act was a proximate cause of Jose Perez's death. A proximate cause is a real cause, a cause without which Jose Perez's death would not have occurred, and one that a reasonably careful and prudent person could foresee would probably produce such injury or some similar injurious result. Third, that the defendant intended to kill Jose Perez. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which the assault was made, the conduct of the parties, and any other relevant circumstances. Fourth, that the defendant acted with premeditation. That is, that the defendant formed the intent to kill Jose Perez over some period of time, however short, before the defendant acted. Fifth, that the defendant acted with deliberation, which means that the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under some influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. They may be proved by circumstances from which they may be inferred, such as the lack of provocation by Jose Perez, conduct of the defendant before, during, and after the killing, use of grossly excessive force, infliction of lethal wounds after Jose Perez is felled, the brutal or vicious circumstances of the killing, and the manner in which or means by which the killing was done. And sixth, that the defendant did not act in self-defense. Second-degree murder differs from first-degree murder in that the state does not have to prove specific intent to kill, premeditation, or deliberation. If you find the defendant guilty of second-degree murder, the state must prove beyond a reasonable doubt that the defendant unlawfully, intentionally, and with malice wounded Jose Perez with a deadly weapon, proximately causing Jose Perez's death. The state must also prove that the defendant did not act in self-defense. Voluntary manslaughter is the unlawful killing of a human being without malice, premeditation, and deliberation. A killing is not committed with malice if the defendant acts in the heat of passion upon adequate provocation. The heat of passion does not mean mere anger. It means that at the time the defendant acted, the defendant's state of mind was so violent as to overcome reason, so much so that the defendant could not think to the extent necessary to form a deliberate purpose and control the defendant's actions. Adequate provocation means anything that has a natural tendency to produce such passion in a person of average mind and disposition. Also, the defendant's act must have taken place so soon after the provocation that the passion of a person of average mind and disposition would not have cooled. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in the heat of passion upon adequate provocation, but rather that the defendant acted with malice. If the state fails to meet this burden, the defendant can be guilty of no more than voluntary manslaughter. For you to find the defendant guilty of voluntary manslaughter, the state must prove three things beyond a reasonable doubt. First, that the defendant killed Jose Perez by an intentional and unlawful act. Second, that the defendant's act was a proximate cause of Jose Perez's death. A proximate cause is a real cause, a cause without which Jose Perez's death would not have occurred. And third, that the defendant did not act in self-defense, or, though acting in self-defense, used excessive force. Voluntary manslaughter is also committed if the defendant kills in self-defense but uses excessive force under the circumstances. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. However, if the state proves beyond a reasonable doubt that the defendant, though otherwise acting in self-defense, used excessive force, the defendant would be guilty of voluntary manslaughter. First-degree murder. So I charge that if you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant, acting with malice and not in self-defense, wounded Jose Perez with a deadly weapon, thereby approximately causing Jose Perez's death, that the defendant intended to kill Jose Perez, and that the defendant acted after premeditation and with deliberation, would be your duty to return a verdict of guilty of first-degree murder. If you do not so find to have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder, but will determine whether the defendant is guilty of second-degree murder. Second-degree murder. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally and with malice, but not in self-defense, wounded Jose Perez with a deadly weapon, thereby approximately causing Jose Perez's death, would be your duty to return a verdict of guilty of second-degree murder. If you do not so find to have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of second-degree murder, but will determine whether the defendant is guilty of voluntary manslaughter. Voluntary manslaughter. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally wounded Jose Perez with a deadly weapon, and thereby approximately caused Jose Perez's death, and that the defendant used excessive force, it would be your duty to find the defendant guilty of voluntary manslaughter, even if the state has failed to prove that the defendant did not act in self-defense. Or, if you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally, and not in self-defense, wounded Jose Perez with a deadly weapon, and thereby approximately caused Jose Perez's death, but the state has failed to satisfy you beyond a reasonable doubt that the defendant did not act in the heat of passion upon adequate provocation, would be your duty to return a verdict of guilty of voluntary manslaughter. However, if you do not so find, or have a reasonable doubt as to one or more of these things, would be your duty to return a verdict of not guilty. And finally, if the state has failed to satisfy you beyond a reasonable doubt that the defendant did not act in self-defense, or that the defendant used excessive force, the defendant's actions would be justified by self-defense, and would be your duty to return a verdict of not guilty. Now, members of the jury, you yourselves have heard the evidence, and you've heard the arguments of counsel for the state and for the defendant. I have not reviewed all the contentions raised by the state and the defendant, that being one of the responsibilities of these good lawyers in their closing speeches to you. And it is then and now your duty to consider all of the evidence and also all of the arguments, contentions, and positions urged upon you by each side in their closing speeches to you. And then you are to weigh them all in light of your common sense and as best you can to determine the truth of this matter. The law, as indeed it should, requires that the presiding judge be impartial. You are not to draw any inference from any ruling that I have made, or any inflection or expression on my face, or from any question I may have asked a witness, or from anything else I may have said or done during this trial. You should not infer that I even have an opinion, or have intimated an opinion, as to whether any part of the evidence should be believed or disbelieved, as to whether any fact has or has not been proved, or as to what your verdict or findings ought to be. It is your exclusive province to find the true facts of this case and to render a verdict reflecting the truth as you find the truth to be. I instruct you that a verdict is not a verdict until all 12 jurors agree unanimously as to what your decision shall be. You may not render a verdict by majority vote. Now, counsel, anything further different pursuant to Rule 21 of the General Rules of Practice, General Statute 15A 1231? Anything on behalf of the state?
No, Your Honor.
Anything on behalf of the defendant?
No, Your Honor.
Everybody feeling okay? Ms. Hobbs, it appears to this court that we have 12 jurors who are ready, willing, and able to do their duty in the trial of this particular matter, and that we're not going to have to burden your time further with this trial. Do you have anything in the jury room?
Yes, sir.
If you will go get that, whatever you need from the jury room, we'll wait for you. You just come right on back in here. You can leave those in your seat. Hobbs, we thank you so much for being with us. I'm going to ask that you'll have a seat in the audience.
Okay. Do you want my notebook to stay
You
there?
can leave it right there.
Okay.
Thank you, ma'am. Correct to reflect that the alternate juror, Ms. Hobbs, has removed herself from the jury box, and the only persons in the jury box are 12 jurors. Now, ladies and gentlemen, your first order of business when you retire to the jury room should be to select a foreperson to lead you in your legal deliberations. Once you've done that, you should deliberate. I'm going to provide for you in the jury room in this manila envelope this verdict sheet which contains your possible verdicts in this case. When you have reached a unanimous verdict, your foreperson will record that unanimous verdict by placing a check or an X mark in the space next to the appropriate verdict on the verdict sheet. Once you've done that, your foreperson would date the verdict sheet. Then your foreperson would print his or her name in the space provided, sign the verdict sheet, return it to this manila envelope, knock on the door, tell the sheriff you've reached a unanimous verdict, and then when you're invited here into the courtroom, your foreperson would bring that unanimous verdict with them in the manila envelope. And if at any time during your deliberations you need to communicate with this court, if you have a question or request, you should do so only in writing. I'm providing this pad and this pen for that purpose. If you have a question or request, write it down on the pad, rip the page off, fold the page over, knock on the door, give it to the sheriff, he'll bring it to me, I'll talk about it with the lawyers, then I'll bring you here into the courtroom and will respond to you here on the record. Is any objection on behalf of the state of North Carolina defendant with this court having the sheriff place the manila envelope with the verdict sheet, the legal pad and pen in the middle of the table in the jury room?
None from the state, Your Honor.
No, Your Honor.
Mr. Sheriff, you'll do so.
Yes, Judge.
The record should reflect that the sheriff has returned from the jury room and no one is in the jury room. Now, ladies and gentlemen, if you have a cell phone, you need to turn it off now. If you've got it back there, you may go get it now and turn it off. The reason we did that is our rules require that only 12 jurors be present in the jury room during their deliberations. If you receive a call and you answer it, we have 13 people in the jury room. If you make a call, we have 13 people in the jury room. If somehow you have forgotten to turn your phone off and it rings, do not answer. I'm going to allow you to take your notes with you into the jury room. Be mindful of the instructions I gave you earlier. These notes are an aid to your individual memory and do not prove anything to any other juror. The recollection of a juror is entitled to the same dignity and respect as the notes of any other juror. Length of deliberations. Just however long it takes. However short, however long. It's whatever it takes. If you get a verdict this afternoon, that's fine. If you don't, that's fine. I'm not going to sequester you. We'll go home at our usual time. We'll come back tomorrow morning and start again. It's however short or however long. It's whatever it takes. So don't be concerned about that. If you don't get a verdict and we call you in at the end of the day, your foreperson should place your individual sheets that I've given you and the verdict sheet in the manila envelope. Bring your notes in with you. I will collect the notes and in the legal pad and will secure them over the evening recess period. We'll collect your notes. No one's going to read them. And they'll be in your seats when you come back in the morning. That way you don't have to leave anything in the jury room. One final word, ladies and gentlemen. The attitudes and conduct of jurors at the beginning of their deliberations are matters of considerable importance. It is rarely productive of good for a juror at the outset to make an emphatic expression of his or her opinion of the case or to state how he or she intends to vote. When one does that at the beginning, a sense of pride may be aroused, and a juror may hesitate to change his or her position of the case, even if shown that it is clearly wrong. You should remember that you're not partisans or advocates in this matter, but rather that you are the judges of the facts. And you should remember that the highest aim of every legal contest is the ascertainment of the truth. Anything for the record for the state?
No, Your Honor.
Anything for the record for the defendant?
No, Your Honor.
Now, members of the jury, you may retire. First, select one of your members as foreperson to lead you in your legal deliberations. When you have reached a unanimous verdict, you may return to the courtroom to pronounce it. With that, you are excused. Record to reflect yours at the courtroom. Anything direct for the state?
No, Your Honor.
Anything direct for the defendant?
No, Your Honor.
Ms. Hobbs, we sure do thank you for being here these last 2 weeks. You're not eligible to serve on a jury in this state for the next 2 years. So if you're called to serve as a juror, let the clerk of that court know about your service here this week, and you are not able to serve there because you don't have the qualifications because of this week. You get paid the sum of $12 for the first day you were here, got $20 for the next 4 days, then you got a raise to $40. Now, I recognize that that may well be a financial sacrifice to you, but it's a small sacrifice for you to pay for you to have the privilege of being a constitutional right this week, not only for Ms. Madonna, but for all of us. Do you have any questions about your jury service? Now, if you want to stay and see what this jury does, you can stay. If you want to be anywhere else, you're free to do that too. I've told you repeatedly not to talk to anyone at all about this case. You may now talk to anybody you want to about this case, except for those 12 jurors, and you may talk to them only after I've accepted a verdict from them. If you need an excuse for your place of employment, they can provide that for you in the jury lounge downstairs. Do you have any other questions or comments? Thank you, ma'am. We are at ease. It's okay to talk to the lawyers if you want to.